This 5-minute case file does not constitute legal advice and does not create an attorney-client relationship with Hoeg law. COPPA, YouTube, the FTC, and You. What is COPPA? COPPA is the Children's Online Privacy Protection Act of 1998. Under the law, commercial website operators who are earning money through their site, are prohibited from collecting personal information from children, individuals 12 and under, without giving notice of their collection policies and obtaining verifiable parental consent, among other things. While personal information includes the obvious, like name and address, it also includes what the Federal Trade Commission, FTC, calls persistent identifiers, like IP addresses or cookies. In addition, visitors to websites that are determined to be directed to children are effectively assumed to be children, and the operator of such a website is held liable for any personal information collected without meeting consent and notice requirements. COPPA has nothing to do with labeling or the content itself. What is the COPPA Rule? Under COPPA, the FTC is charged with making, what you might hear referred to as promulgating, rules that give meaning to the words actually approved of by Congress. When the law was first passed, and again in 2013, the FTC drafted a rule, the COPPA Rule, to help establish just what directed to children actually meant. Under that rule, the FTC established that directed to children means targeted to children. Not much help, right? They also established that in determining whether a site is directed to children, the FTC will consider a variety of factors including subject matter, visual content, use of animated characters, child-oriented activities, music, age of models, presence of child celebrities, language, other characteristics, and empirical data regarding audience composition. It is on this vague, we'll know it when we see it definition that the strict liability of website operators or sites directed to children is premised. Note that the COPPA Rule itself also acknowledges that while the factors might lead one to believe that a site or service is directed at children, it might actually be for mixed or general audiences. In such a case, the rule provides that a simple age gate prior to data collection will prevent most liability. We'll get back to that. How does this affect YouTube? On September 4th, 2019, the FTC, along with the state of New York, announced a settlement and consent order under which YouTube and Google were required to pay $170 million and provide for a mechanism on their site that would allow content creators to designate their content as directed to children, if applicable. The settlement was based on allegations that YouTube was labeling visitors to its site with persistent identifiers, tracking them across sessions, and serving up behavioral advertisements based on those identifiers. As such labeling was done regardless of login status, which would have been limited to ages 13 and up, and included visitors to channels the FTC believed were clearly directed to children, YouTube was alleged to be liable under COPPA for such data collection. How does this affect content creators? In connection with the consent order, the FTC held a press conference in which it asserted authority under COPPA to sue not just YouTube, but also content creators as the operators of their individual channels, because YouTube was offering a For Kids button, as well as an interest-based behavioral advertising toggle. The FTC's theory goes, commercial content creators had sufficient control of their website to prevent illegal data collection, and thus constitute operators under the law. This despite the fact that content creators never approved of YouTube's data collection policies, never touched any of the data, and could not comply with COPPA, which requires parental contact, even if they desired to do so. While the FTC's claim stretches the wording of COPPA and the rule to the limit, it must be taken seriously, as any defense against it, even if successful, could only be undertaken in court at significant time and expense. Further, the FTC reserves the right to fine violators up to $42,530 per violation, though any enforced amount must take into account principles of justice, including the ability of the operator to pay. As such, any enforced fine would likely be much lower in most circumstances. Also worth noting is that YouTube itself could have assuaged fears and limited creator exposure by limiting data collection, providing notice, obtaining parental consent, or even providing the previously mentioned mixed audience age gate, but instead elected to leave creators to fend for themselves and to seek legal counsel when contemplating their exposure under COPPA. What's next? Despite their definitive press conference statements, the FTC has never before brought a COPPA claim against a content provider operating a channel or feed on another operator's website, and the theory of their case, that YouTube is the creator's service provider authorized to collect data for this purpose, is a difficult one to make. In terms of the rule itself, the FTC is currently soliciting public comments on revisions through December 9, 2019, and Jeremy Johnston of J-House Vlogs has created a Change.org petition, which creators can join to ask the FTC to reflect on these subjects and more. Finally, if you are interested in really diving into the legalities of the subject, we at the Hoeg YouTube channel have a number of long-form virtual legality videos looking at each of these issues in substantially more detail. Please check them out if interested, and let us know what you think.